Have you ever heard of a court case that was so massive, it completely changed the record books on human rights violations? Well, we're about to break down a judgment that did exactly that. And it shines a huge spotlight on a major problem in one country's entire justice system. 239. Just look at that number. This isn't just some random statistic.
This number represents a bombshell.
It's a bombshell. This is how many times the European Court of Human Rights found the nation of Turkey violated a fundamental legal principle. And get this, it was all in one single case, Demirhan and others v. Turkey. So what on earth did these 239 people do to trigger this? Well, they were accused of being members of the Gülen movement, which the Turkish government blames for the 2016 coup attempt. For the vast majority of them, the entire case against them pretty much boiled down to just one piece of evidence. They used an encrypted messaging app called ByLock. Okay, to really get a handle on just how big of a deal this is, we need to talk about the core legal principle that this entire historic ruling is built on. It all comes down to Article 7 of the European Convention on Human Rights. It's the principle of no punishment without law. I mean, it's pretty simple, right? You can't be found guilty of a crime for doing something that wasn't illegal when you did it. This is literally a cornerstone of modern fair justice systems. And here's where it all went wrong. The proper legal standard says you have to prove someone is guilty as an individual and that they had actual criminal intent. But that's not what the Turkish courts did. Instead, they basically said, hey, if you used ByLock app, you're automatically guilty. They just skipped the whole part about needing individual proof.
Now, you might be thinking this just came out of nowhere, but it really didn't. The stage for these mass convictions was actually set years earlier, creating a really critical legal precedent.
So let's just quickly walk through how we got here. It all kicks off in 2016 with that failed coup attempt. After that, we see a wave of mass prosecutions, and they're all leaning super heavily on this ByLock evidence. Then, in 2023, a landmark case called Yalçınkaya sets a huge precedent which really paved the way for this 2025 Demirhan judgment, the one that basically confirmed, yes, this is a systemic, ongoing problem. That Yalçınkaya case was a total game changer. It was the very first time the European Court of Human Rights flat out said that convicting someone almost entirely based on their use of ByLock was a major violation of their rights. Not just the right to a fair trial, but also that no punishment without law principle we just talked about. This ruling really set the stage for everything that followed. All right, so 239 wrongful convictions have now been recognized by the highest human rights court in Europe. Case closed, right? Justice served. Well, this is where the story takes a really unexpected and frankly, pretty controversial turn. I mean, it's the obvious question, isn't it? After everything they went through, years of being wrongfully locked up, the public shame, all the money spent on legal fees, did these 239 people get any compensation for all that suffering? The answer, unbelievably, is no. In a move that shocked a lot of people, the court decided that just declaring a violation had happened was, and I'm quoting here, sufficient just satisfaction. They got nothing for their emotional distress, nothing for the damage to their reputations, and the court even refused to cover their legal bills. And you should know, not everyone on the court agreed with this. One of the dissenting judges, Judge Shembri Orland, put it perfectly. He said that for all the effort these people went through, they deserved, at the absolute very least, to get their legal costs and expenses paid back. This lack of compensation is even more stunning when you zoom out and look at the bigger picture. Because this wasn't just a mistake or a few bad calls, it was a clear pattern of systemic abuse. Wow, just look at this chart. It really says it all. In its entire 64-year history, the European Court of Human Rights had found only 63 violations of Article 7. In this one Demirhan case, it found 239. Let that sink in. That is nearly 4 times the number of violations from the court's entire history, all found in just one judgment. Now, when you see a justice system carrying out such widespread, systematic, and arbitrary punishments against a specific group of its own citizens, well, the source material we're analyzing here argues that this starts to align with the definition of a crime against humanity. It's a very heavy term, and it points to a deliberate state policy. And this isn't some fringe idea. The United Nations has been sounding the alarm on this for a while. The UN's Working Group on Arbitrary Detention has said repeatedly that this kind of widespread, systematic imprisonment in Turkey could amount to crimes against humanity.
And the Demirhan ruling is a huge deal because it's not just about detention, it's about convictions, which is an even higher legal bar.
So after a judgment this monumental, what does it all mean for the future of justice in Turkey? Where do things go from here? Well, the implications are massive. For one thing, there are over 8,000 similar cases still waiting to be heard. On top of that, Turkey has shown it's not complying with the court, continuing the very practices that were condemned back in the 2023 Yalçınkaya ruling. The source material has a name for this: autocratic legalism. It's when a legal system is basically weaponized for political goals instead of being used for actual justice. The way forward is clear, but it's not going to be easy. Step 1. Turkey has to start following the court's rulings. Simple as that. Step 2. A lot of deep structural reforms are needed to make sure the judiciary is actually independent from political pressure. And finally, the source suggests that international bodies, like the Council of Europe, really need to step up and apply more pressure to make sure these changes actually happen. And all of this leaves us with one last, really critical question. When the very courts that are supposed to uphold the law are the ones systematically breaking it, how much power does international justice really have to hold an entire nation accountable?